Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 263 revision proceedings. The name of the case is Sharp Mines and Minerals Private Limited versus Principal Commissioner of Income Tax. This case has been reported in 117 ITR Tribunal at page number 67. The matter has been decided by CUTTACK ITAT and the date of the judgment is 18th August 2022. As all we know that nowadays a number of the cases is being picked for revision under section 263. 263 gives the power to the commissioner to revise the order passed by the assessing officer if the order is erroneous and prejudicial to the interest to the revenue. Both the condition should be simultaneously fulfilled to initiate the proceedings under section 263. Apart from that, there is a condition that there must be some order which can be revised. If there is no order, no revision can be done. If this analogy is stretched, then the concept comes out that if the assessing officer has passed an order which was limited scrutiny order, and limited scrutiny was on two issues, like in the present case, the case of the assessee was picked for limited scrutiny because the assessee has shown excess liability and the department has the information that there must be some disallowances under section 40A subsection 3. The assessing officer covered both the matters, the assessment order was passed. This was limited scrutiny. But after some time, the principal commissioner initiated the proceedings under section 263 on the matter to verify the valuation of the closing stock. But interestingly, in the present case, the valuation of the closing stock was not part of the limited scrutiny. But when the assessee objected this revision by saying that the matter which is not covered under the limited scrutiny can also not be taken under the revision proceedings, was not entertained by the commissioner, and he go ahead with the revision proceedings. When the matter was before the ITAT said that there are two important instructions of the department regarding the limited scrutiny. That is, first instruction is 7/2014, which was issued on 26th September 2014. And the second instruction is 20/2015, which was issued on 19th December 2015. If the crux of these two instructions are analyzed, then they say that if the assessing officer wants to travel beyond the limited scrutiny, then he has to take the permission of the commissioner. So once an order is passed on the limited scrutiny, only revision can be done on those points on which the limited scrutiny was completed. If a matter is not covered under the limited scrutiny, then even the commissioner do not have the power to take that matter in revision proceedings also. So in the nutshell, in the present case, if during the assessment proceedings, the assessing officer wants to travel beyond the limited scrutiny, then first of all, he should take the permission at that time of the commissioner and then cover up the matter. And after that, if the commissioner feels that the assessing officer has not done the proper verification, then he can do revision. But in the present case, the situation is little bit different because the matter on which the commissioner wants to do the revision under section 263 was not part of the limited scrutiny at the time of the assessment proceedings. So in the facts and circumstances of the case, the commissioner is not justified in initiating the proceedings under section 263 on a matter which was not part of the limited scrutiny. Friends, when we receive some notice, we try to reply the points which are there in the notice. But first of all, we should see that whether the notice of the department covers the jurisdictional requirement of issuing that notice. Jurisdictional requirement does not mean that whether it should be issued by AITO or BITO. The conditions of issuing the notice under that section must be fulfilled before issuing the notice. Otherwise, that notice is not valid. At the end of this video, once again, I am repeating the name of the case. The name of the case is Sharp Mines and Minerals Private Limited versus Principal Commissioner of Income Tax. And this case has been reported in 117 ITR Tribunal at page number 67. The matter has been decided by CUTTACK ITAT and the date of the judgment is 18th August 2022. Thank you, friends.